Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, exactly 365 days ago, we floated this YouTube channel where the idea and the endeavor has always been to solve legal issues, to create legal awareness, legal issues that are both basic and complex, and to guide law students to achieve and fulfill their dreams, fulfill their endeavors, and to do it in the simplest of the way so that it's easier for everyone to understand and comprehend it. Now, today's topic for discussion is very special because it is on pleadings, plain and written statement under the Code of Civil Procedure. Now, pleadings, as we all know, are forming the foundation for any case in a court of law. They form and they are like the backbone of any legal suit because the case is generally set out in the pleadings, and it is the Code of Civil Procedure that lays down the fundamental rules of pleadings along with the amendments to the same. Now, there are certain questions that every law student has, and even young lawyers for that matter. What facts have to be pleaded? Law has to be pleaded or not, and only material facts to be have to be relied upon, or is it every fact that has to be relied upon? Should the evidence also be included or not? Now, in what circumstances can amendment of a pleading be permitted? How do you structure a plaint? When is it barred by res judicata? What are the objections that the respondent can take when he files his written statement, and what are the key elements of drafting a pleading? So joining us today on the virtual amicus, well, it's a matter of great pride for us because joining us today on the virtual amicus is someone who needs absolutely no introduction. It is a matter of great honor for me to introduce to you our speaker, our panelist for today's session is the former Chief Justice of Honorable Bombay High Court, former Chief Justice of Honorable Rajasthan High Court, and former Judge of Honorable Delhi High Court. It's a matter of great honor for me to introduce Honorable Mr. Justice Pradeep Nandrajog, sir, who will be doing this session for us, who was kind enough to give this consent. Well, when the authority on civil laws does a session, you cannot afford to miss this one. So, sir, anything that you wish to say before we start with our segment, sir?
Thank you, Jay, for having given me an opportunity to share something. What I say is back to the classroom. It's so fundamental about pleadings, and as we see, the experience in life tells us that whatever is elemental is tended to be forgotten. So it's good that on your first anniversary, you are going back to the basics, what is elemental. And I greet all the participants whom I cannot see because we are in a virtual mode. A very good morning. I won't say a very sunny morning because right now we would all be very happy if we get a little bit of clouds in the sky. The weather has been playing trance with us, but nonetheless, we are doing a great job. But probably if you go by the Christian ethics, on the wrong day, when God created earth, the seventh day was the day of the Sabbath. We were all supposed to rest on the day of the Sabbath, and it's a sin to be working on the day of the Sabbath. But nonetheless, society has modified its norms and it has modified its values. And as we will proceed along with the lecture, we would find that the same thing has happened to the laws relating to pleadings. With that, Jay, do I have your permission to get along with the meat of the topic?
Definitely, sir. The floor is all yours. Over to you, sir.
Thank you. So we are discussing pleadings. And as the word suggests, it comes from the word plead. And the word plead is a verb. It's a doing word. So the moment we describe a verb, every contours which are encompassed in the doing of that verb needs to be incorporated. For example, we say Ram is running. So running is a doing word, it's a verb. But if Ram is running in an open terrain, if Ram is running on a riverbed, if Ram is running on an obstacle course, we must specify where is Ram running, so that the person to whom the running of Ram is being described is able to understand the contextual context in which Ram's running is being described. So when we say a pleading is something which conveys to the reader in the writing the thought of the writer. So what is the writer supposed to keep in mind when he is conveying his thought in writing to the reader? He must pose the first question to himself: what am I saying? He should then posit the question, why I am saying. He should then posit the third question to himself, what am I required to say? Because if you are saying something which does not match with what you are required to say, then your saying, your speaking would be blurred to the person who's hearing, and similarly, your writing, that is your pleading, would be blurred as well as slurred. And then the third, why I am saying. So in a plaint, you are saying something because you want a particular relief. So what you would be saying, merging with what I am required to say, with the why I am saying, that is the prayer clause, forms the template of your pleadings. So answering the aforesaid three questions in a harmonious manner is the essence of the pleadings. Where did we get all this from? So let's have a look to the historical perspective of what has emerged in the rules of the civil procedure in India relating to the law of pleadings. During the classical period of the Roman law, disputes were defined in the formula, which in today's context becomes the issues which are settled by the court. On what basis does the court settles the issue? That is traceable to the classical period of the Roman law, where disputes were defined in the formula, and the formula was a written statement setting out in brief language what was the exact issue between the parties. And we find that exactly mirrored in today's concept of settlement of issues. What does the judge do when he settles the issue? He records a brief statement setting out what is the exact issue between the parties. So during the Roman era, the procedure was that the claimant, who could also be labeled as the complainant, issued an in just vacatio, which would be an informal statement of the nature of the claim, initiating the process requiring the praetor, who was a high-ranking magistrate, to summon the defendant to appear in court and answer. So it was an informal statement of the nature of the claim. And this gets transformed to what we call is the plaint today. But during that period, it was never in writing. The claimant would go to the praetor orally tell him what his problem was. And after listening to the problem, if the judge would find out that a legal claim was made out, which we call today, the plaintiff must disclose the cause of action. If a judge finds the plaintiff fails to disclose the cause of action, he will not issue summons and will never call upon the defendant to come and reply. So during the Roman classical period, the praetor would listen to the claimant and find that do these facts which he is telling me make out a case for grant of relief requiring me to call the defendant by way of this summons. So the defendant would appear on the date notified, and in his presence, the claimant would again state what his case was. The praetor would ask the defendant as to what his version was. Then after listening to the defendant on his version, if the judge found that the parties were at variance on an issue of fact or law, he would immediately settle the issue, requiring the parties to lead evidence. But if he would find that there were lack of clarity, then he would call upon the claimant to respond to him by what the defendant said. And if the plaintiff introduced something which required the defendant to further explain, so he would continue with this process, hearing A, hearing B, hearing A, hearing B, hearing A, hearing B, till he crystallized the issue of fact and or the issue of law on which the parties were at variance. And of course, when he would do that, he would also keep in mind that the pleas raised before him were of a kind which were acceptable in law and were justified by some kind of evidence which could be brought. We find under the Commercial Court Acts its reflection in terms of summary judgments today. Once the pleadings had been heard, they were reduced into writing as the formula, that is the issues. So issues of the formula was what we call in Latin the litis contestio, that is to say, joinder of the issues. Once under Roman law, the joinder of the issues took place, it prohibited alteration of the pleadings and barred any further future action on the same issues between the parties, which we today call as and refer to as res judicata. Why? Because it serves the cause of a society well if issues which are confronting the parties are settled once and for all. And therefore, the obligation on the parties to present their facts, their pleas in law, in their pleadings, and we are conscious of the fact that the law of res judicata, as it stands enacted, says issues which you were supposed to raise when the cause of action accrued, if you did not raise them, unless under Order 2, Rule 2, you have taken the leave of the court, you would be stopped from raising the issues at a later stage. The formula stipulated to the judix, that is the judge, who was a non-lawyer. There were no formal law degrees then. It stipulated to the judge what he was supposed to focus upon. And the second stage of the system was on the trial of the formula before him. So formula was thus the instruction to the judge dealing with facts he had to establish and how the case should be decided as a consequence. We find that in trials today, if parties tend to lead evidence which is having no bearing on the issues, the judge is entitled to say that you have to focus on the formula, which in turn takes its colors from the pleadings. That is to say, it helped the parties as well as the judge to focus. An issue not in formula could not be raised at the trial, but within that boundary, the judge was the judge of fact and law and exercised a wide discretion. English law was much less sophisticated in its earlier days than the classical Roman law. Ordeals of fire, water, wager, judicial combat was settled, manners were such which required no pleadings, they required no proof. Supernatural proofs and oaths which they tested were absolute and inscrutable. No legal questions were asked, no reasons given, no facts found, no rules declared. We find a remnant of this in the Indian legal system even today. You would be aware of the Special Oaths Act. If a litigating party challenges the opponent to take a special oath and that person takes the challenge of the special oath and under oath he states a fact, then the challenger cannot question that. It is based on the belief that humans would not lie to their God. And India, the Kul Devta or the Gram Devta. But these are hardly used. In my career as a lawyer, first for 22 years, then as a judge for over 17, and back as an arbitrator in the next 2 years post-retirement, I have not come across anyone in India laying a challenge under the Special Oaths Act. And probably it's a reflection that today we believe that people would even lie on the oath of affirmation of truth in front of their Kul Devta or their Gram Devta. So, however, in the 12th century, with the advent of jury, even in England, as a more rational way of settling civil disputes through pleading with it, this was because just as the Roman judex, that is the judge under the Roman law, had needed the formula, the jury had to know what issues it had to decide. The pleadings served another function too, because they disclosed whether the issue was one of fact for the jury to decide or one of law for the judge to decide. But today in India, it is irrelevant because we've done away with jury trials, but it continues to be relevant because it guides the judge that what are the questions or issues of law which he needs to decide, which are the issues of fact which he needs to decide. So even as they were under the Roman law, they were similar in its reflection in the English law when the earlier advent of civil jury trials originated in the 12th century. Pleadings were conducted orally at the bar of the court and moderated by the judge until the 15th or the 16th century. So the plaintiff would set out the facts of his complaint in what was known as the declaration. You could call it a narration. You could call it a count. Today we call it a plaint. The defendant had 4 options in making his defense, which was known as his plea. So what the plaintiff would say would be a declaration or a narration or a count. What the defendant would respond was his plea, which we find today gets converted into a plaint or a written statement in a court. In arbitration proceedings, we call them statements of claim or statements of defense. The label hardly matters. What matters is, in writing, the plaintiff states what his case is on fact and in law, and the defendant in response states his defense on facts as well as on law. As I said, under the classic Roman law and earlier parts of the British law, the defendant could raise his plea, that is his defense, which could be put in 4 categories. Now, what are the 4 categories? He could make a general traverse, which amounted to a denial of all the facts pleaded in the plaint. That is to say, he put every fact stated in the plaint an issue by filing a written statement of a general traverse denial of everything. This pleading does not require any replication. Why? Because the plaintiff is not required to respond to anything more now. The defendant has denied everything. And I do feel still sorry. I've come across replications, contents of para so-and-so of the replication of the written statement are wrong and denied. So-and-so of para of the plaintiff is reiterated because the defendant has picked up every sentence of every paragraph of the plaint and denied. And in a mechanical way, the replication keeps on reaffirming it. So keep into account that if the defendant takes a general traverse, denies everything what has been said in the plaint, tell the judge straight away, please settle my issues and proceed with the trial. Or he could make a special traverse, which was a denial of some material facts, admission of some material facts. This also doesn't require any replication. Because of 10 facts pleaded in the plaint, 5 is admitted, 5 is denied. So on those 5 he's denied, the judge can settle the issue straight away and proceed for trial. No replication needed if the pleadings in the written statement are of general traverse or of a special traverse. He could well put in a plea of what we call as a demurrer. He demurs. So what is a plea of demurrer? I admit everything what the plaintiff says by way of facts, yet he is not entitled to any relief. This again would not require any replication and would not require any trial. Why? Because the law of evidence tells us that evidence would be led of the facts in issue and such other facts which are hereinafter made relevant. This is the definition which flows out of Section 5 of the Indian Evidence Act. So in a plea of demurrer, an issue would be settled straight away, whether on the pleadings and the plaintiff is entitled to the relief claimed for or not. Since we are discussing pleadings, so please put it in your heads clearly. A written statement of a general traverse, a written statement of a special traverse, a written statement on a plea of demurrer would not warrant any replication. A written statement of a plea of demurrer would require no evidence to be led because the defendant has not traversed any fact pleaded in the plaint. He says that on these facts being treated as correct, the plaintiff cannot be granted any relief. If it is a general traverse, on all the facts, the plaintiff would have to lead evidence. On a special traverse, only on such facts which have been denied. This understanding of the rules of pleadings would also help us when we record evidence and when we argue. Many a times you would have seen the facts which the defendant has not denied. In witness statements, even those facts are pleaded in the affidavit by way of evidence. That's why I said pleaded. If it was an oral statement, the plaintiff goes about stating those facts and unnecessarily puts to cross-examination. The two lawyers and the judge are overlooking the fact that this particular fact need not have been deposed to by the witness because it was an admitted fact. The fourth category of pleadings in the defense are the complex one, which I need to halt upon for some time and explain in a little detail with reference to some examples. The defendant in the written statement can make out what we call as pleas of confession with avoidance. And generally we find that large number of written statements fall in this category. Now, what is a plea of confession with avoidance? Confession with avoidance is a plea where the defendant admits the facts which have been stated in the plaint. So he confesses to that. But then he sets up pleas of avoidance. He introduces certain facts and then says that because of these facts which I am introducing, the plaintiff is not entitled to the relief. So confession and avoidance admitted facts pleaded in the plaint, but introduces new ones to explain them and hence make out a defense. So confession and avoidance do not therefore produce an issue because they require the plaintiff to respond to what? Only the pleas of avoidance in the written statement. To the extent the defendant has confessed to the plaintiff's plea in the plaint, the replication should not reiterate those. Now, at this stage on a plea of confession with avoidance, relating to the facts pleaded of avoidance, the plaintiff has to respond. Now, law gives the plaintiff the same 4 rights which the defendant had to bring in his written statement. So in his replication, he may plead demurrer. All right. The defendant, having admitted the facts which I have pleaded, has introduced these facts on which he claims an avoidance. I don't want to confront him on those facts. Even if these facts which he seeks by way of avoidance are treated to be correct, he's still not entitled to succeed on his defense. So if he files a replication stating that, again, no trial is needed. Why? Because it is the establishment of the pleas of avoidance which would now non-suit the plaintiff. Because the plea of confession with avoidance is that on the facts admitted, the plaintiff would be entitled to the relief, but because of the pleas of avoidance, he would not be. And if it's a plea of demurrer in the replication to the facts stated by way of avoidance in the written statement, same situation of a plaint being met with a written statement of confession with a plea of demurrer in the written statement. But if the response of the plaintiff is a general traverse or a specific traverse, no further pleadings. Why? Because the pleas of avoidance have been generally denied in their entirety or specifically denied in a part. So parties are clear where they are at variance with. But if in the replication, the plaintiff admits the pleas of avoidance set out in the written statement and introduces further pleas of avoidance, that is to say, the replication may say, okay, if this what the defendant states is admitted by me, but in view of these further facts which I disclose, the defendant is not entitled to the defense. This replication would then need a rejoinder to the replication. Normally, we use the pleas of replies and rejoinder in writ proceedings. But if in a civil trial, we reach a situation where the replication has introduced facts in relation to the pleas of avoidance pleaded in the written statement, met with confession followed by an avoidance, now the defendant would have to file a response to the pleas of avoidance relatable to the pleas of confession in the replication. Unfortunately, the defendant may respond in the same manner. This will require the plaintiff to file a sur rejoinder. And in the sur rejoinder, if the defendant does the same thing, it may require a rebutter. And in the rebutter, if the plaintiff does the same thing, it will call for a sur rebuttal. Why? Because the trier of the facts, that is the judge, has to reach the stage which the Roman praetor did. He kept on asking the parties, you say this, 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 till he crystallized the exact issue of fact and exact issue of law. Why? That it requires the judge to reach a point which is affirmed on fact by one side and denied on the other. They are then said to be at issue. All their debates being at last contracted into a single point, which now must be determined either in favor of the plaintiff or of the defendant. To understand this nebulous concept, which has been stated by me up till now in a theory, let's take an example. A files a suit against B for recovery of 1 lakh rupees. And the plaintiff says that the plaintiff is a hardware merchant. The defendant is a petty contractor. In the course of his business as a petty contractor, the defendant requires such material which are sold at the hardware shop, such as paints, paint brushes, nails, screws, nuts, bolts, saws, etc., etc. And it was orally agreed between the plaintiff and the defendant when they commenced their business relations that the defendant would either himself or through his authorized representative pick up goods from the plaintiff's shop on credit, and at the end of the month, the account used to be settled and the defendant would pay the amounts by check. And then he says that in furtherance thereof, in the month of January, February, March, and April, the defendant cleared the amounts. For the month of May, when the accounts were settled, 1 lakh rupees was payable, and the defendant gave me this check in sum of rupees 1 lakh, which when I presented for encashment was returned by the banker of the defendant with the plea payment stopped. Therefore, a decree of rupees 1 lakh and interest thereon at the rate of 18%. The defendant admits all these facts. He said, yes, the plaintiff is a hardware merchant. I'm a petty contractor. We had an oral agreement under which I used to buy the goods on credit. At the end of the month, the accounts were settled. And upon being settled, I used to issue him a check. I admit that in the months of January, February, March, and April, whatever he gave to me on credit, at the end of the month, the accounts were settled. I gave him a check. The amounts were cleared. And he also says, yes, this check also I gave. So all pleas of confession. Now starts the plea of advisance. But this check was not issued for the month of May. This check was issued by me to the plaintiff as a blank check in the month of January when we commenced business, because the plaintiff wanted it by way of security. And in support of this plea, he writes, the check number is 22. I have issued check number 23, 24, 25, and 26 for the months of January, February, March, and April to the plaintiff, thereby establishing that this check was obviously issued before the month of January, February, March, and April. And then he says that in May, the plaintiff told me to carry out painting, polishing work in his house. And it was agreed that for the painting, polishing work, he will give me labor charges of 30,000 rupees. Then he says that in the month of May, the material which I picked up from the plaintiff's shop for my own consumption, and some material which I picked up not for my own consumption, it was to be consumed in the plaintiff's house. So when I went to settle the accounts with him, the material which was consumed in the plaintiff's house, he put it to my account. So what is the pleas of avoidance? Number one, that I did work worth 30,000 in the plaintiff's house for painting and polishing. So I'm entitled to an adjustment of 30,000. Next, we had a problem on settlement of accounts. Such material which I had picked up but was for the plaintiff's use in his house, he started billing me for this also. Then he says that when I was doing the work of painting and polishing, two of the almoras was so badly termite eaten. I told the plaintiff that these almaras are badly eaten by termites. So the plaintiff told me that please get them replaced. I got in touch with a carpenter who quoted his rates for wood and labor at 50,000. Acting as the plaintiff's agent, I engaged this carpenter to whom I had paid 50,000 rupees. So in addition to my labor charges of 30,000, this 50,000 which I paid to the defendant, to the carpenter, even that needed adjustment. So when I went to settle the accounts, three problems arose. One, the material which I had picked up and used in the plaintiff's house, he started billing me for that. And he refused to adjust the labor charges payable to me, the charges payable to the carpenter. Why? Because he said that till you don't agree that the entire material which you have lifted is to your account, I'm not going to give you credit for that. And then he says that I had lifted material worth only 70,000 rupees to my account. So far from giving anything to the plaintiff, he had to give me 80,000 rupees. So adjusting 70,000 for the material which I have picked from the plaintiff's house, shop, I'm entitled to 10,000 rupees and he lays a counterclaim for 10,000 rupees. So this defense is all on pleas of avoidance. Now, the plaintiff is to respond. So the plea of avoidance that goods worth 30,000 which were consumed in the plaintiff's house were being included by the plaintiff in the statement of the material bill. He has to reply to that. The plaintiff says, material worth 1 lakh which the defendant picked up does not include the price of the material in my house. So therefore, on one plea of avoidance, there is a clear denial. So on that plea of avoidance, that the material which I consumed in the plaintiff's house was also being included in the statement of the material billed has been met with a denial. No further pleadings on this. There were two other pleadings of avoidance, that the plaintiff was to give me 30,000 for my labor charges and was to give me 50,000 rupees for the carpentry work which I got done. Now the plaintiff says, yes, it was agreed that the defendant would do painting, polishing work in my house. It was agreed that I would give him 30,000 rupees as labor charges. Yes, it was agreed it would be adjusted from the money due by the defendant to me for the material lifted. But the defendant did shoddy painting and polishing work. Therefore, I am not liable to pay him any money for painting and polishing because the work was shoddy. And in fact, I had to redo it myself. So the plea of confession that the defendant was to be paid money for labor charges incurred for painting and polishing is met by a plea of avoidance, that the work was shoddy. On the carpenter part, he says, yes, he got the carpenter, but he was not to pay the carpenter. The carpenter's 50,000 rupees I have directly paid to the carpenter. So this plea of third part of avoidance of the carpenter has been met with a plea of confession with avoidance. So two pleas have been met with confession and avoidance in the replication. These pleas will require a rejoinder. Now let us take in the rejoinder, the defendant says, he's telling a lie, he is not paid to the carpenter, so he's just denying that plea. So the issues of no avoidance. Then on the plea of shoddy work, he says, I deny I did shoddy work. I deny that the plaintiff had to redo the work. So the pleas of avoidance, following the pleas of confession by the plaintiff, have been met by pleas of denial. And now we are at the stage where parties are clearly. So what would be the issues between the parties? Whether the defendant lifted goods worth 30,000 to the account of the plaintiff, which were consumed in the plaintiff's house. Why? The plaintiff says he picked up goods worth 1 lakh. The defendant admits I picked up goods worth 1 lakh, but says 30,000 worth goods were spent on the plaintiff's house and 70 to my account. So on the goods lifted, the issue would be settled very clearly. The defendant has not denied having lifted goods worth 1 lakh lifted. What he says is 70 to my account, 30 to the plaintiff's account, and the plaintiff says the entire 1 lakh to the defendant's account. So the trial is going to take place not on goods worth 70,000, but only on respect of 30,000. Were they to the plaintiff's account or were they to the defendant's account? Next, no evidence to be led that 30,000 rupees was the labor charges, because the plaintiff admits that I had to give that labor charges. The defendant has not to prove that under an agreement he carried out painting polishing work. The dispute is whether that painting polishing work was satisfactory. So the issue would be whether the painting polishing work done by the defendant was substandard, thereby casting no obligation on the plaintiff to pay to the defendant labor charges. Correct? And then on the woodwork, no issue to be framed, no evidence to be laid, whether there was a carpenter who came and did the work. The plaintiff admits that at my asking, the defendant did it. He also admits that the carpenter's bills were 50 lakhs, 50,000. So the issue would be whether 50,000 rupees payable to Masram the carpenter were paid by the defendant or by the plaintiff. So this is a good illustrative example to make us understand that in 90% of the claims where we will find the plaints are met with pleas of confession with avoidance as to how we have to focus on our pleadings. Why? Because at the end, the judge has to set the formula, which is the issue, which will guide the parties as to what evidence has to be led, which would guide the judge as to what evidence he has to record. This would have an advantage that the trial would be focused, that huge time spent on useless evidence being brought on record is not brought on record, and the parties exactly know where they have to meet the combatant. it would strike you that the origin of the pleadings was in the context of the society which existed then and the nature of disputes brought before the trier of the fact for adjudication. Its origin was where commercial transactions were oral. In 99% cases, 100% evidence was oral. Very seldom were claims predicated on written documents. Today, the position is reversed. Civil except family disputes relating to partition and succession, all commercial disputes are litigated on written documents. There would be written agreements, series of letters, and email exchanged. And that is where, Jay, when you said, should pleadings contain my evidence? Well, the law says pleadings should not contain evidence. But when this was said, don't forget that the Code of Civil Procedure 1908 had a predecessor, Code of Civil Procedure 1868. So those procedural laws were settled, keeping in mind the kinds of societies which existed then and the nature of disputes which exist now. So thus the word pleading, which is a generic term to describe the formalized process by which each party states its case prior to trial, has virtually led to the demise of the word pleadings, and it would be more appropriate to call the modern day pleadings as a statement of case of the litigating parties, which we find that at least in arbitration, we don't call plain written statement, we call them statements of claim and statements of defense and statements of counterclaim. So the observations of the Supreme Court and the decision reported as 1988, Volume 4 SCC 534, Bharat Singh versus State of Haryana, though relevant to a writ pleadings, have assumed relevance to a pleading contemplated by the Code of Civil Procedure in relation to a plaint or a written statement. The observations of the Supreme Court are in para 13, but they were relating to a writ petition. Now, those of us who draft writ petitions, don't we see that in a writ petition, a pleading of fact is made good with reference to an annexure annexed? A pleading of law is also made good with respect to a annexure. So a pleading in a writ petition is a pleading of fact, pleading of law, and pleading of evidence as well. This is what the Supreme Court said. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such fact is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. But the next part of what the Supreme Court said, we will find gets even diluted when we look at the Code of Civil Procedure. The Supreme Court said, in this context, it will not be out of place to point out in this regard that there is a distinction between a pleading under the Code of Civil Procedure and a writ pleading or a counter affidavit pleading. While in a pleading, in a plaint or a written statement, the facts and not evidence are required to be pleaded. In a writ petition or in a counter affidavit, not only the facts, but also the evidence and proof of such facts have to be pleaded and annexed to it. But we would see when we will look at a little closer to the provision, the Code of Civil Procedure, the Supreme Court missed the point. How did it miss the point? Now I'll be a little specific. So Order 2, Rule 1 of the Code of Civil Procedure requires the suit to be drafted so that by a single decision, all subjects and disputes are decided to prevent further litigation concerning them. It traces it back to the classical Roman era, reflected in the British law, reflected in what we call as res judicata today. Why? The suit must be drafted so that by a single decision, all disputes are decided so further issues do not confront the parties. The next is Order 7, Rule 1E. Particulars to be contained in the plaint. We don't have time. We have to go through the entire Order 6 and Order 7, but I'll just pick up the core areas. What it says, facts constituting the cause of action and when it arose. Why the cause of action? That all such facts which must be proved to entitle you to a place would be your cause of action. One word of caution. And when did the cause of action accrue? So facts constituting the cause of action with the fact when the cause of action accrued, I still find pleading. The cause of action accrued when the agreement was entered into. The cause of action accrued when in furtherance I supplied. The cause of action further accrued when he made part payment. No. Those are facts constituting the cause of action. Don't use the word and accrued. The cause of action is distinct from the cause of action accruing. It accrues when the plaintiff is denied the benefit of the money for the goods. Then the cause of action to sue accrued when the defendant refused to make final payment under the invoice, stating that the goods delivered were partly found to be damaged. So please keep in mind that the facts constituting the cause of action have to be distinctly pleaded, and the fact when the cause of action to accrue. Why? Because the law of limitation says, if you read the Limitation Act, it says when the right to sue accrued. So it says limitation of 1 year, 3 years, whatever, when the right to sue accrued. Please keep that in mind. I find a lot of diffuse pleadings on this critical aspect. Pleadings of my cause of action are distinctly severable than the plea. When did the cause of action to sue? The word to sue, right to sue increase. From there, the limitation comes into being. Then, Order 7, Rule 3. Where the subject matter of a suit is immovable property, you have to sufficiently describe the property. Order 7, Rule 5, I find is missing in 99.99% of the plaints today, regretfully stated. The plaint should show that the defendant is or claims to be interested in the subject matter and that he's liable to be called upon to answer the plaintiff's demand. Please read Rule 5 of Order 7. I find no pleadings today that in what manner the defendant claims that he's interested in the subject matter and why is he liable to be called upon. Now let us see, in the example which I gave, if the plaintiff who was the hardware merchant, obviously there was a dispute between him and the defendant for the month of May. He knew it. He knew that the defendant is not agreeing to the statement of goods issued by him. He knew that he had called upon the defendant to do work in his house. He knew that he had called upon the defendant to get a carpenter. He knew that when they were negotiating, the defendant must have raised some dispute. Okay, look, Mr. Plaintiff, this material which you say you have given to me, I have not consumed into my account. I have consumed it to your account. As your agent, I did painting, polishing work in your house. And how do you say that you have paid the money to the carpenter? I paid the money to the carpenter. If this plaintiff had called upon as to how the defendant is liable to answer, all this rejoinder, sur-rejoinder, rebuttal stage would not have come. If the plaint was that he did this work, he did shoddy work, therefore I'm not liable to pay him anything. My 1 lakh of rupees doesn't include even a penny for the material supplied, not supplied, given to him and consumed in my house. And the carpenter I've already paid. You would have been so focused. You would have been so focused. The judge's focus came, written plaint, written statement of plea of confession with avoidance, replication with pleas of confession with avoidance, and a rejoinder to the replication where pleas of general traverse of all pleas of avoidance was done. So please keep into account, the plaint must say in what manner the defendant is accountable, and in that deal with such facts which are in your knowledge, which the defendant would ultimately raise in the written statement. Say in your plaint, he said this to me, but he's wrong because of this. Why? In what manner he is liable. Now, where the suit is instituted after the expiration of the period prescribed by the law of limitation, the plaintiff should show the grounds upon which the exemption is claimed. For example, minor, insanity, anything, whatever it may be. Now comes where Jay started. What should my plaint state? Should it bringing my evidence as well? So we have Order 6, Rule 2 to guide us. Every pleading shall contain only a statement in a concise form of the material facts on which the party pleading relies from his claim or defense as the case may be, but not the evidence by which they are proved. So this part, the last sentence of sub-rule 1 of Rule 2 of Order 6 conforms to what the Supreme Court said in that case which I had just referred to of 1984 Supreme Court in Bharat Singh's case, where the Supreme Court said that in a writ pleading, evidence would also have to be laid, but would not have to be laid in a suit. So obviously the Supreme Court was guided by the language of sub-rule 1 of Rule 2 of Order 6. It says, but not the evidence by which they are to be proved. Well, let's go a little further. I'm not going into Order 2, 3 pleading paragraph consecutive figures. But look at the impact of Rule 4 of Order 6 on sub-rule 1 of Rule 2 of Order 6, which rule said you will not plead your evidence. But what does Rule 4 say? In all cases in which the party pleading relies on any representation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid, shall be stated in the pleading. So, Sub-rule 1 of Rule 2 of Order 6 requires the pleadings to contain a concised version of the material facts. But what do we find? That sub-rule 4 expands, and what does it bring in? Material particulars. So dear friends, keep in mind, the requirement of a concise statement of material facts contemplated by sub-rule 1 of Rule 2 of Order 6 is enlarged by Rule 4 of Order 6. What is the enlargement? The concise statement of material facts has to be expanded, telescoped into material particulars. I'm not at Order 6, condition, precedent, and all that. Now, dovetail Rule 9 of Order 6 into what? So we started off by Sub-rule 1 of Rule 2 of Order 6, concise statement of material facts. Rule 4, with material particulars. Now let us say, wherever the contents of a document are material, it shall be sufficient in any pleadings to state the effect thereof as briefly as possible, without setting out the whole or any part thereof, unless the precise words of the document or any part thereof are material. Are we not directly into evidence now? What? Where the contents of a document are material, its effect would have to be stated. So where do we get? Link sub-rule 1 of Rule 2 of Order 6 to sub-rule 4 and sub-rule 9. In the context of today's litigation, where everything is documented in the forms of emails, minutes of meetings, letters. So, effect of the document, meaning thereby that what the parties infer. And regretfully, again, what I find is, what are the pleadings? The plaintiff sent an email dated so-and-so, the respondent responded by an email dated so-and-so, the plaintiff sent an email dated so-and-so, he sent an email. It's so diffused. The effect of those. So in other words, in today's context, the rules of pleadings of writ, which the Supreme Court was referring to in Bharat Singh's case, flow out of Order 6, 3 provisions, sub-rule 1 of Rule 2, sub-rule 4 and sub-rule 9, dovetail it with that provision where I said sub-rule 5 of Order 6, that in what manner the defendant is liable to the plaintiff, put all 4 together. And what do we have is a negation of what the Supreme Court said, that in a suit, the pleadings should not contain the evidence. They were only influenced by the last part of sub-rule 1 of Rule 2. The lordships overlooked sub-rule 4, sub-rule 5, and they overlooked the sub-rule 9. Therefore, in today's context of pleadings, Rule 9 of Order 6 is the most important rule, which requires to state the effect of the documents which are material. And it is this rule which in today's context requires pleadings virtually to be the same as was highlighted with the Supreme Court in Bharat Singh's case, relating to writ pleadings. Now, the legislature in India is sleeping, but we find that in England, reforms in pleadings have been put into place under the Civil Procedure Rules 1998. The word pleading has been given a timely demise, and in place we find the expression statement of case. So if you do international arbitrations, and good, it's refining itself in the Indian arbitration, in the statement of case, it's not a pleading, it's a statement of your case. What is my case? That the defendant is liable to sell his house to me. And why should he sell the house to me? It should not only start with the agreement, it should also state what steps were taken by the parties, which is the evidence. He did this, I did this, I wrote to him, I went there, I got the money, and then he started backing out. So it's this. So if we find that, we find that the Indian context also requires today to proceed in the manner, in spite of the fact that the Civil Procedure Code continues to be what it was. But we find these 5 provisions of the Code of Civil Procedure, which I have pointed out to you, in light of the origin of the rules of pleadings in their historical perspective, how they emerged. And dear friends, keep one thing in mind. What does Darwin's theory of evolution tell us? Darwin's theory of evolution tells us that species which have not evolved with time have perished. So, lawyers as a species, if will not evolve with time, will also perish. What is the evolution of time? Mammals continued to remain mammals, but hundreds and thousands became extinct because they didn't evolve, and hundreds of thousands continue to survive because they have evolved. So, as modern day business continues, today, through the world of the internet, you can be in virtual communication through emails. There was a time when everything was oral. Then there was a time when everything had to be put down in letters. You had to go and post a letter. And people would say, all right, is चिट्ठी का जवाब कल दे दूंगा, परसों दे दूंगा, भूल जाऊंगा. But today we don't find that. Today, every hour, we check our mobile phones for emails. And the moment we get an email of a kind which we need to promptly respond to, we promptly respond to the email there and then. So what we are finding in today's context is that the steps which the parties have taken, which would be the steps of their conduct, which falls within the realm of the law of evidence, has been documented by the parties. So as they traverse the journey of their togetherness pursuant to a contract, at every stage, they are keeping a memorandum of the evidence of their conduct. And those of you who have done these trials would have noted that at the end of the day, all that witness statements and cross-examination is hardly used. And in fact, we waste so much time. What do the witness say? And we keep on saying, document, fact, document admitted, contents denied. What do we mean by contents denied? What we mean is By contents denied, how can you deny the contents of the document where that is the content? What we intend to say is inferences recorded by the witness in that mail or the letter is denied by us. But that is not a matter of evidence. That's a matter of inference. So see, dear young friends, what has happened? We have muddled our procedures of drafting. We have muddled our procedures of evidence. We have muddled our procedures of drawing inferences to such an extent that we have made our litigation cumbersome and time-consuming. Today, the grievance of the consumer of justice, I have not come across a consumer of justice who says that I am getting substandard justice. His grievance is, I am getting so delayed justice that it has become virtually meaningless for me. What is the point for me to litigate for so long? Companies have gone into liquidations, they've gone into bankruptcy because their cash flow and their fund flows have got badly damaged. So the grievance today, when you go to the chambers of commerce, industry, businessmen, I haven't come across people saying, I am not satisfied with the judicial verdicts which is coming from the courts. The grievance is that it is becoming so time consuming. It has become a test not of my case, but it has not become a test of the strength of my case. It has become the test of my personal physical endurance. That, according to me, dear friends, can easily be avoided if we keep into account what I have just stated, that the pleas of confession with avoidance can be avoided in a properly drafted claim because the plaintiff knows that this is what the defense would come. If he says in what manner he makes the defendant accountable in spite of the defendant taking the stand, it will help the parties being focused. It will curtail the time spent on litigation. It would help the judge allocate his time because after all, a court sitting time is bound to be 5 hours. The judge has to allocate all that. And if you can do it, and in my considered opinion and my humble opinion, it can be done. The only thing is that hours of midnight oil burnt in drafting the claims and the pleadings of the claims in the defense as well would save hundreds of hours wasted before the adjudicator of the fact, be it the arbitrator, be it the court. I had committed about an hour and a half to Jay because I know that anyone viewing anything for more than that time, you tend to fast track I also do that. Sometimes when we are seeing a talk or something which is recorded, if you find that it is getting too much stress, you tend to fast track it. All of us are short on time. I would like to open the floor for any questions from the participants. And Jaya, would you be taking the questions or I would be taking the questions directly myself?
So first of all, sir, I wish to thank you on a brilliant presentation, sir. We've had many extraordinary sessions on the virtual amicus, but this definitely qualifies to be the most enlightening session ever recorded. It was an absolute honor having you over, sir. So we are joined by Mr. Nitish Bagri, sir, a seasoned advocate practicing before Honorable Rajasthan High Court at Jaipur bench.
Yes.
Mr. Bagri, can you hear us? If you could unmute yourself.
Good afternoon, sir. Good afternoon, sir.
Good afternoon, Mr. Bagri. Yes, put your question. Yes.
Sir. So I wanted to know whether the judges, when they are adjudicating in the writ petitions, whether they like that the judgments extract should be placed in the writ petitions, or it should be purely on the factual and legal basis, not quoting the precedents in the writ petitions?
Well, it is like this. If unnecessary copious paragraphs are picked up and put in the writ petition, then of course it annoys a judge. But if you follow the format of a proper writ petition in respect of a pleading, so follow what Bharat Singh's case says, the writ petition must contain pleadings of fact supported by the evidence to make good the fact, followed by the grounds of your relief. So what you do in a writ petition, so we always have facts, then grounds. So if you are putting your judgments in the grounds, let's understand if a judge has got, say, 70 matters on the board.
Sir.
He doesn't, in the house after he's corrects the orders which he has dictated, some short judgment which he tells in the court, bhai main allow kar raha hu, dismiss karunga, jara order chamber mein likha dunga, otherwise it will be time wasted. So you know 3-4 such orders. Then he's entitled to a little gossip with his friends as you are entitled to gossip with your friends.
Yes, sir.
Then some long judgment to read and all that. So it becomes very irritating for a judge if on the first part where your facts with evidence with annexures, there you start feeding in your judgments. Sometimes you'll see before the facts come, the first 20 pages in such and such judgment, this was held, this was held. So it gets very irritating. So the judge will go into your grounds if from your facts he finds something emerges. After all, he's also an experienced person.
Yes, sir.
And let me tell you one thing, judges don't read horizontally, they read vertically.
Yes, sir.
Because if a judge is supposed to read horizontally and then he's got 70 files with him, the guy doesn't have time. What maximum about 2 hours he spends on going through his briefs. So
Yes,
he reads them vertically, do it, but do it in a packaged manner. No harm in quoting precedents, but do it in the grounds. And don't quote copiously. 4 paragraphs from a judgment you quote. Just say, ultimately that the crystal which emerges from that judgment, because in the judgment reported so and so this was held. Now, if the same point is held in 20 judgments, so you put all 20 in your grounds.
That is not going to serve the purpose.
So just say it as held in this, followed in this. Make it. Don't you find neatly packaged things when you go to the market? Something which is neatly packaged, don't you buy it?
Yes, certainly.
And something which is lying fluffy, you say you don't buy it. So your plaint or the counter affidavit is also a material for a judge's consumption.
Yes, sir. Yes, sir.
Right. Yes. Any other question?
Also, sir, I wanted to know that in the recent times, there has been a habit of putting a very detailed synopsis, which is equivalent to the number of pages the facts have.
Right.
So the synopsis are running in 30 pages. The writ petition fact is actually running in 20 pages. So they are making more or less the synopsis equivalent to writ petitions.
Yes.
With an assumption that judges are only reading synopsis and not going through the contents of the written annexure. How fair is that practice? Because personally,
I'll answer it like this.
We were always
yes, I'll answer this.
2 pages.
One perversion leads to the other perversion. When the judge would find that his synopsis is as large as the writ petition, he says, then why should I read the writ petition? So you have corrupted the system. So in other words, you made the judge a drug addict to the synopsis. Now, your problem. So how do you de-addict a drug addict? If you remove the drugs, then he'll die. So you'll have to detoxify very slowly. Yes, so having created the mess, somewhere we have to out. So I'll answer it like this. You see, this synopsis and all came as a result of very lengthy pleadings. That is why judges said synopsis. Then synopsis got confused with list of dates and events. So some High Court said you would give the list of dates and events. Some started using the word synopsis. But the intention behind the list of dates and events is this, that it was introduced by judges because they would have to pick up a pen and start reading the pleadings and start making some kinds of notes, which became time consuming. So the list of dates and events and the synopsis were actually a ready-made thing for a judge not to pick up his pencil. So he would just look at that, look at the thing, he says it's there, and it would help him getting focused. Now, in the writ petition, you will have to state, as I said, your facts. You would have to refer to the annexures. You would also have to say that in why you are making an inference from particular annexure. So that pleading would be a little argumentative, right? The argumentative part of it at least can be removed. Now let's accept Nitish. It's a lawyer's creation. साहब एक बार रेट बना दी, अब इसको कंडेंस करने में टाइम लगेगा, चलो इसी को चेप देता हूँ. This is what you do, na?
Yes, sir. Certainly, sometimes.
Always. If the two are going to be the same and one is not going to be a mirror of the crystal of the other, then what's the point? The tendency is, अब इसको कहाँ crystallize करूँ? Now, that is where I think the onus is on the lawyers. And how would your juniors grow? उसको बोलो अब तू इसकी प्रेसी करके लाना. So in the synopsis, well, let us take in a writ petition, you are pleading promissory estoppel. The promissory estoppel will emerge from a particular notification. That notification would be preceded by something which required that notification. And let's take, it's a case of a government incentive under a scheme. And you want to plead that because of this incentive, you altered your position. Your factory which was there, you brought the factory over here because this was the subsidy being given. And then you would say that now, having made me alter my position based on that subsidy scheme, under the garb that the legislature or the executive has a right to change the policy in public interest, they cannot take away my right because I had a legitimate expectation. Now, so you will then start pleading facts that in the budget, the government introduced this, there was unemployment over here, this. So a writ petition would be elastic. But in your synopsis, why can't it be intended for the purposes of the economic development of, say, the sub-tribal area in so and so, the government introduced the bill? Just one line. So in the synopsis, that background would not be there. Just one line. For industrialization, such and such bill was introduced. Next, to give effect to clause 12 of the bill scheme. Don't make it so. A scheme for subsidy. In the writ petition, how the subsidy has to be claimed, what. So make the synopsis what the very word synopsis is. And then when you say that you believe that the judge won't read it, let me tell you one thing, which you must have also seen. As you grew as lawyers, can't you sniff something and get the feel of it?
Certainly.
Similarly, the judge also gets in the same manner. And you are right that judges don't read the writ petitions. Why? Because your synopses are as big. But if a judge looks at a 30-page writ petition is preceded by a 4-page synopsis, he'll be happy. Whatever he can understand from this synopsis, fine. And let's understand, the reading by the judge is not to decide the case. The purpose of the judge reading your brief is to control the proceedings on the next day. At least he should know what the matter is all about. Unfortunately, be truthful about it. How many writ petitions we filed which we know on day one will not even last anything? Don't we file them?
Certainly, sir.
Even I was a lawyer, I used to do the same thing.
Certainly, sir. If the client insists and we know the fate of the writ petition, we
file it for two reasons. Let's say one is lawyer centric. भाई चलो ये इसने तो तय कर ही लिया, ये पैसे खर्चेगा, ये कहीं ना कहीं फेंकेगा तो मेरे को ही दे जाए. कोई ना कोई वकील इसको बोलेगा. Why should I not do it? Let's be practical. Or the second is sometimes what you think is a writ petition is a flyer point. It might stick. And let's understand what does our experience tells us. At least 3 to 4% of the flyers point do stick.
Yes, sir.
And they do stick. So we do that. So answering your question theoretically will not be possible. But the purpose of these talks is that what does a lawyer sell? Time and knowledge. And what is the only asset with a judge? Is time and knowledge. So if the business administration principles will tell us that exploit your resources to the extent maximum return comes. So if your only two assets are your knowledge and your time, exploit them to the best.
Thank you, sir.
Any other question?
Sir, in fact, I have two questions, sir, but only if you have the time, sir.
Yes, we have the time. Carry on.
So, two quick questions. Number one, don't you feel these days as lawyers, they directly start practicing before writ courts and they lack that necessary skill set that you require and that grooming that is important before trial courts? Don't you think that if you could talk us through your experience and if you could...
Yes. I joined an original side lawyer and I started taking up writs after I honed my skills at suit pleadings. But then, Jay, what to do? The number of lawyers is too large, and the number of lawyers with work constitutes a very small percentage of the total bar strength. Work is concentrated in some hands. So if you are joining a senior who's got a wide and varied practice, you can afford to be groomed under him, and he can afford to groom you by first telling him, trial work karo, plain banao, witness affidavit by way of evidence banao. How many of us get that privilege? How many of us get that privilege? Then how many of us gets that privilege to be working in senior chambers where decent remunerations are given? Let's face the truth of reality. 90% of the lawyers who are joining lawyers, that 90% who have less work, they pay them nothing. So whatever he gets. But you are right. Law as taught in theory is so different than law as it is practiced in courts. Unlike doctors who do clinical work, who are associated with doctors, who assist them in surgeries, who assist them in treatment, a law student, when he comes to the legal practice, is not subjected to the vagaries of actual litigation. So he's not. But yes, there is, I think now there is a consideration in the Bar Council as well, that till you don't practice in the district courts means trial work. Till you don't do trial work, you will not be practicing in the High Court. Don't forget that before the Advocates Act, first everyone was enrolled as a pleader and then as an advocate. So till you had not done trials, and I entirely agree, what you learn by experience is the biggest teacher. Yes, principally I agree with you.
Sir, and to add to that, do you think language is a barrier, sir? Because on the original side here in Rajasthan, the state of Rajasthan, before trial courts, medium of instruction, drafting, pleading, everything happens more or
Yes.
less in Hindi. So do we miss out on a lot of meritorious, a lot of talent in the process? Because most of the law schools these days, including national law schools, everything happens in English. So do you think that?
Yes. Look here. I started off by saying that what is the three core essence of pleadings? What am I saying? Why I am saying? What am I supposed to say? So if I understand what am I supposed to say, if I understand why I am saying, but I am lacking in what am I saying, it fails. So a good communication skill, a good language skill is extremely important for a lawyer. In every aspect, forget about pleadings. See criminal trials, murder trials. Invariably, witness गवाह के कहता है, मैं अपने झुग्गी में बैठा था, रात का 8 बजे का समय था, 7 वाली झुग्गी में राम प्रसाद और उसकी पत्नी गीता देवी झगड़ रहे थे और वो the judge is recording, they were fighting. Up now the witness, the lawyer should understand कि देखो ये झगड़ रहे थे का क्या मतलब होता है, and that झगड़ रहे थे get translated into fighting. Now, till you have your language skill that between two persons, it could be quibbling. Quibbling becomes squabbling. Squabbling can become quarreling. Quarreling can become fighting. So till I don't know that these 4 words exist, quibble, squabble, quarrel and fight, out of these first 3 have no physical element. It is only the 4th which has a physical element. Don't we get cases in murder cases? ये 2 दोस्त थे, ताश खेल रहे थे, दारू पी रहे थे, उसने उठा के उसका सिर फोड़ दिया. उससे पहले जोर-जोर से झगड़ रहे थे. They were 2 friends. Why should he smash his head? So that part of it, it started with the quibbling. Quibbling became squabbling. Squabbling became quarreling. And it reached to fighting. So language skill is extremely, extremely important. So even when, let us take a plea of fraud, a plea of coercion, a plea of misrepresentation. Now, apart from knowing law, the skill should be there. Now let's take, for example, I have this glass. I pour some gin in it, which I don't tell you, but I put some water. And I tell you, Mr. Bagri, Jay, would you drink water? And you say yes, and you drink it, and then you get intoxicated. So what will you sue me? I have taken your consent to drink water, but I made you drink alcohol. So the content is vitiated by a misrepresentation which amounts to a fraud. I have fraudulently taken your consent. Why? Because the consent was to drink. I asked for your consent to give it for drinking water, but I made you drink alcohol. But suppose I put gin in it, right? And then put some water and say, Jay, Natish, gin piyoge? And you say, sir, ये gin क्या होती है? तो मैं कहता हूँ ये tonic होती है. So what have I taken your consent? I have taken your consent to drink gin. You have consented to drink gin, but the consent has been obtained on a misrepresentation. right? There is a deception in fraud, there is a deception in misrepresentation. But one kind of deception takes it as fraud, the other kind of deception takes it as misrepresentation. So in the second case, if you have to sue me, you will sue me for, in the first, thought of fraud, in the second, thought of misrepresentation. Correct? You saw the distinction? Next. Suppose I put gin in it, and then I say, Jay and Natish, I'm giving you gin. It is alcoholic. It will cause toxicity. And then I take out a gun. I said, I will shoot you if you don't drink it. I have taken your consent to drink gin. I have taken your consent to drink with clear knowledge that it will intoxicate you. Correct? But what have I done? I have taken your consent under coercion. Coercion. So in the third case, you will sue me neither for tort of fraud nor for a deception or misrepresentation, but you will sue me for under coercion. And what is the coercion? That under that, what was the threat to your body? And coercion is defined under section 17 of the Contract Act. Now, like fourth, if I put gin, I say, Jay, Nadish, pilo, mera dil toot jayega, I will feel very bad. Then you can't sue me. You can't sue me. Why? I told you everything. At best, what did I do? I pestered you, na? I just pestered you that I'll feel bad. So therefore, answering your question, a language skill is extremely, extremely important. Now comes the point that English is the language of communication in most of the good law colleges. But then the practice by the lawyers is in places where the work is conducted in Hindi. That's what you say. And I used to find it very funny. And if you see your the people who crack the judicial exams, 80% of them have all studied in public schools and they have they've studied in good law colleges. So somewhere they have to write judgments in Hindi, but they get the pleadings in Hindi. So the linguistic skills are good. There I refuse to believe that because the pleadings are in Hindi, it creates a problem. The only thing is you have to find the exact equivalent of that word. And you have good dictionaries of Hindi to English, English to Hindi. It's just that if you think in a particular language and you are called upon to write or speak in a different language, your work gets a little more tedious. And let me tell you, if you move in society, you will learn that how everybody perfects his skill. And I'll give you one little very funny anecdote. I had a house in the hills in Missouri, and once my tap, I had I will use the word tap only, in my wash basin needed a replacement. So I had nothing to do. I was on a holiday. I walked up to the hardware merchant shop and he saw me and he said, Jacha, kya chahiye? I said, your shop is there. You sell it to other people. I just have to buy a small thing. I'll pick up the newspaper and read it. So I sat on the bench on the mall on the Missouri main road from the library end to the Picture Palace end. And when I saw that his shop was just left with one or two customers and I walked in. So one fellow told him, ek nalka de do. So this guy had a 50 rupees in his 2-4 fingers clutched like this. You know, you would normally give the money, ek nalka de do. So he said, yahi paise hain tumhare paas? He said, yes. So he tells his shop attendant, isko ek tuti de do. So he gave him a polymer tap. So when he left, so I asked the shopkeeper, I said, "Bhai, usne to nalka manga, tumne kaha tuti." So tuti nalka same hote hain. पानी निकलता है। इसे नहीं जज साहब, जो पॉलीमर की होती है उसको टूटी बोलते हैं, वो 75 रुपए से नीचे की होती है, 35 रुपए से 75 रुपए तक की होती है। और नलका जिसको आप पुराने जमाने में कॉपर का बोलते थे, दिस इज कास्ट आयरन विद द पॉलिश ऑन इट, तो कहते हैं उसको नलका बोलते हैं, जो लोहे का बना होता है। वो 150 रुपए से लेके 200 रुपए का आता है। फिर जो क्रोम वाला होता है उसको टैप बोलते हैं, और टैप आता है आपका 225 रुपए से लेके 500 रुपए तक का। और वो जो फिर दोनों जो जो मिलते हैं उसको मिक्सचर बोलते हैं, वो 750 रुपए से ऊपर के होते हैं। सर मुझे एक मिक्सचर दे दे। See how the common man, for the same thing, it's an implement from which you can regulate the flow of water. So generically, when we say a tap, what would it be? It would be defined as an implement from which we can regulate the flow of water, right? But this instrument from which we can regulate the flow of water for the common man would be tutti, nalka, tap, mixture. So if he can hone his skills rather than wasting time, suppose he says, साहब एक नलका दे दो, rather than wasting the time, भाई प्लास्टिक का दूं, रॉट आयरन का दूं, क्रोम प्लेटेड दूं, मिक्सचर दूं, है ना? The buying and selling process will get lengthy, would it not? तो अगर ये प्लीडिंग ऐसे रहती तो एडजुडिकेशन लंबी हो जाती। उसने कैसे छोटा कर दिया? टूटी, नलका, tap, mixture. So why can't our pleadings also go in the same? Tutti pleadings, tap pleading, nalka pleading, mixture pleading. So society tells us these are not insurmountable problems. Yes, सब possible है. Yes, language is always a barrier. And that's why we say you have to cross the language barriers. If you move from one state to the other state, you will have to cross language barriers. Answer is yes, but that doesn't mean that's the end of it. It just needs a little bit of hard work. Just needs a little bit of hard work. Something very interesting I saw when I became a lawyer for the first time. I mean, 81. So 82, there was some lawyer in the Supreme Court. He said, draft an SLP. Now the rules of SLPs have got changed. Previously, the SLPs were virtually like, this was his case, this was. So it was a case from a Mufassal area in Uttar Pradesh. So it was a suit for injunction. And normally you'll find in the written statements even now, preliminary objection standard, the suit is without cause of action, is frivolous, intended to cause harassment to the defendant. है ना? Standard होती है ना? चाहे वो whether we have a fact or not to plead, but लिख दो. है ना? The suit is frivolous, malafide, so and so. So very beautiful preliminary objection 1. Dawa bavaja. है ना? Bevaja means without cause of action, intended to cause and harass the defendant. Angusht khundki hai, fingering the defendant. So preliminary objection 1. Dawa bawaja, full stop, angusht khundki hai. So what did that pleading tell us? That pleading tells us that the common man's language was also the judicial language. And if the common man's language can put a point with lethal precision, why don't we put it? Correct? I'll give another example. Today we don't read that. That book has gone out of circulation. Moga's Laws of Pleading. Because lawyers stopped buying it, so they stopped publishing it. In Moga's Laws of Pleading, there's a very beautiful plaint. I was very impressed with that plaint. The plaint was drafted in 1925. It was a case of a dog bite. See the beauty of this plaint. The plaintiff was a commission agent in cloth. The defendant's dog had bitten him when he was going for his morning walk. So the plaintiff had to get anti-rabies injections. So the lawyer was told by this defendant कि मेरे को आगरा से कसौली जाना पड़ा for the anti-rabies injections. So the law, see the beauty of the lawyer. So the lawyer said that this fellow has gone for anti-rabies injections, leaving Agra for Kasauli. So he is out of business. He's a commission agent. So I will have one pecuniary damages claim. I can quantify it. इतने दिन मैं business के बाहर रहा. Then my pecuniary damages for the medical treatment. And my pecuniary damages for medical treatment will have two elements. एक जो डॉक्टर की और दवाई के पैसे, और क्योंकि कसौली गया तो कसौली में मैं वहां रहा भी. So the pecuniary was, one was for loss of business. Number two, pecuniary falling in two categories: medical treatment, traveling to the place where medical treatment was to be given, and staying. And the third was pain and trauma, non-pecuniary. So the plaintiff's lawyer knew कि इसके claim monetary 3 heads में जाएंगे. Now see the beauty of the plaint. The plaintiff writes in house number so-and-so, gully so-and-so, Nai Mahalla, Agra. The defendant resides in the adjoining house. Next, see the beauty. The defendant has kept a dog known to be of an irritable nature. This word, known to be of an irritable nature, has casted the obligation of duty of care on the defendant at a higher pedestal. Why? Because dogs have been domesticated from wild animals for thousands of years. By nature, dogs have become human-friendly. Exception to the human-friendly dogs are the dogs which bite. If you go on the street, out of 1,000 dogs, only 1 or 2 bite. Others come and wag their tails. So this lawyer was aware of the rule of Rayland versus Fletcher. So in the pleading, by drafting, the defendant has kept a dog known to be of an irritable nature. Is the beauty of the pleadings. Next. On such and such date as the plaintiff went for his morning walk, the defendant's dog, who was outside the gate of the house of the defendant, negligence prove कर दिया ना कि कुत्ता बाहर छोड़ दिया, and duty of higher care, that the defendant knew the dog is of an irritable nature. He ought to have taken extra steps to keep his dog leashed and not. Then he won't say that today the dog bit the plaintiff. The dog pounced upon the plaintiff and caught the right wrist in his jaws. As the plaintiff wrestled to free himself from the jaws of the dog of the defendant, he fell down, and the dog left the right wrist and caught him by the left shin. Continued the trauma. Now kindly see what? Concise statement of material facts with material particulars. What was the material fact? The dog bit. What were the particulars? You uchla, right wrist ko pakda. As I wanted to free myself, there was jostling, I fell down. Now, this continued trauma will enable the judge to give non-pecuniary damages. Now, suppose you are a judge. Jiska kutta kaat gaya, vis-a-vis this version. Which will get more pecuniary damages? The second one. Because in the one there is trauma and the other is continued trauma. Next. The plaintiff went to Dr. Chobakmal, who gave him immediate treatment and bandage and said that you will have to take anti-rabies injections, for which the plaintiff had to travel to Kasauli, the nearest place available. 73 of the Contract Act, mitigation of damages. So this pleading, he had to go to Kasauli, the nearest place available. Meaning thereby that a good drafted pleadings a good drafted pleadings always, a good drafted pleadings, a good drafted pleadings focuses on the evidence, focuses on the law, and anything which is focused is always quicker and faster. तो इसमें कोई linguistic skill नहीं है, चाहे आप इसको हिंदी में कहो, चाहे आप उसको इंग्लिश में कहो. फर्क सिर्फ यही है कि the thought of deception leading to fraud, thought of deception which is misrepresentation, you just have to pick up the equivalent Hindi word and put it there. There is, I frankly speaking, today you will find, and if you are a trial lawyer, I always used to find that many a times in the language, the mother tongue of the judge, you could give an example to make the judge understand better than in English language itself. And then let's also not forget, Nitish, अब English, Hindi courts में सब जगह, I was in Bombay also, वो मराठी, Hindi, English, सब mixture सही चलता है. Any other question?
Sir, I obviously had one more, but I think already taken 2 hours, sir, of your precious. So
Okay.
I'll probably let it pass.
Right.
It's probably on amendment of pleadings, but I think that will require a separate session on order 6 to 7.
You see,
That way,
amendment would take place in a slightly more, it's a little more technical. We could do it some other time.
Yeah,
we can have some.
we can obviously let it
Okay. Right, Jay. Right, Natish. Thank you very much.
Thank you so much, sir, for taking our time for doing it and making our anniversary memorable, sir.
Thank you.
So, thank you so much, sir. Once again.
Thank you. God bless you both.
Thank you.
And God bless all the participants as well. Thank you.
Thank you, sir.